Hello, welcome to the April 2nd Dickinson Law Firm Compliance webinar on recent enforcement actions and litigation. Today's webinar is actually a continuation of a webinar I did last Wednesday, March 25th. In that webinar, I talked about the TILA-RESPA integrated disclosures and privacy notices and the new rule on privacy notices and determining whether your institution can use the new method to provide annual privacy notices or not. During that webinar, unfortunately, this section of it cut off on recent enforcement actions. So I'm re-recording it here and providing it out to you so that you can get the benefit of what my walls heard, as I was apparently talking to no one. So without further ado, I'll jump into it. Recent enforcement actions is what we're talking about. I'll also highlight a recent developments at the Supreme Court that impact compliance. The focus here, that the enforcement actions that I'll talk about revolve around BSA, fair lending. There's some UDAP worked in here, and that's really RESPA, so RESPA marketing agreements. Those are areas that we're really seeing a lot of enforcement actions from recently, particularly with the CFPB on the scene. Even though all of these actions, some of them are settlements from the Department of Justice, others are FinCEN or state attorney generals. Despite the source of the action, I think the CFPB has been a big part in ramping up these enforcement actions, particularly around fair lending, unfair deceptive practices, and consumer lending and credit cards, areas like that. So the first enforcement action I'll talk about involves a large bank, Commerce West Bank, and BSA violations. So this case arose out of a civil complaint from the Department of Justice that the bank knowingly facilitated consumer fraud. What happened? The bank had a third-party payment processor as a customer. And this third-party payment processor itself was initiating transactions on behalf of merchants. And many of these merchants were fraudulent merchants, like a fraudulent telemarketing company or a payday lender that was instituting fraudulent fees. So the bank was processing these transactions and ignoring a lot of red flags as they mounted. So what were the red flags? Well, here's one. It's a third-party payment processor. That's already going to be something that a customer that you should pay closer attention to because they're moving money around. Second red flag, I think, it's a payment processor based in Vegas. So here in Iowa, I think that may raise a little bit of increased scrutiny to the account, raise a bit of red flags. Third, there was a lot of customer complaints on this. Customers were complaining, and all the bank did was block the complaining customer from transactions with this third-party processor. That's not really solving the problem. Fourth, there were even complaints from other banks that were returning transactions. Despite all these red flags, even after the bank actually uncovered that fraud was going on, they still didn't take immediate action. So they still waited 2 months to terminate the contract and were then even given a third-party processor another 30 days under their contract with them to wind down their business. So 3 months, really, after the fraud, they were letting this customer continue to transact at the bank. You won't hear attorneys say this that often, but in this instance, disregard the contract. You have a deposit agreement with some, in this case, third-party processor or other customer. When you detect fraud, I don't care what your contract with that customer says about what termination rights they have and rights to cure and whatnot. You need to cut that off immediately to cut off the risk of fraud running through your bank. So the takeaway here is really to act swiftly when you're faced with any consumer-related fraud. Here, this isn't a situation that I don't think any of you are really going to have, because this really involved knowing almost intentional levels of allowing fraud to occur at a bank. That's not something that's going to happen here to most banks in Iowa, but nonetheless, the takeaway of acting swiftly, I think, is a very important one. The next is another BSA issue. This was a little bit smaller bank. A $1.5 million fine, civil money penalty was issued against a $1 billion bank. And so a community bank. In Iowa, by Iowa standards, this would be a relatively large community bank, but nonetheless, it's something that's a little bit more relatable to Iowa community banks. In this instance, this is a really, really sad case, I think. The CMP was based on, again, failure to follow up on red flags and failure to file suspicious activity reports. But what was happening here, there was judicial corruption going on. So there were two judges here in Pennsylvania, and they were actually using their position as a judge and sending juveniles to certain detention facilities in which the judges had a financial interest. So that's really terrible. And stack on top of that, what was happening, one of the judges was also a member of the bank's board of directors. So he was the one that was really orchestrating the way the money went through the bank and the way that the funds were handled. So, very sad case here. I mean, very blatant. How can you imagine two judges, people you should trust, sending children to certain detention facilities for their own financial gain, right? That's disgusting. And so the red flags here, interesting red flag, I think. One of the red flags cited by FinCEN was a subpoena issued by a law enforcement agency. So the bank got a subpoena. It responded to the subpoena. So there's no accusation that they were not responding. They gave the law enforcement agency the information that was requested. But the bank didn't, by getting that subpoena, they didn't raise any red flags. They didn't make any other inquiry. They didn't change the risk rating on the account to give it more oversight. So keep that in mind when you get something from a law enforcement agency, be it a subpoena or other request for information. You might want to ramp up your oversight of those accounts as well. Other red flags were large abnormal transactions on the account that were being flagged. And then the SAR issue. The bank didn't file a SAR until after charges were filed against these two judges. So that's a little bit too late in the game. There were suspicions arose prior to that. So the takeaways here are, one, when in doubt, file a SAR. No one's ever been fined for filing a SAR when they didn't need to or shouldn't have. But there's multiple cases like this where a bank gets fined for failing to file a SAR when they should have. And you can somewhat see where the bank here was coming from. So you have a prominent judge who's a member of the bank board of directors, who's likely a prominent leader in the community. That is, why would the bank ever think that this person would be involved in something like this, sending children to detention facilities for their own gain? So the other takeaway is there's nothing too bizarre or unlikely in the BSA area. And for BSA and suspicious activity reporting purposes, trust no one. So that may seem very cynical. I'm not suggesting anyone use that mantra in their day-to-day life, trust no one and nothing's too bizarre. But in the BSA area, I think it really is good advice and it doesn't matter who it is, whether it's a board member, a prominent person in the community. For SAR purposes, trust no one. By filing that, you're not making an accusation. You're not bringing any law enforcement action against them. You're just protecting the bank's interest and fulfilling the bank's duty to file SARs when there's suspicious activity. The next one involves fair lending. So every year there's always fair lending issues. This one I highlighted because it really checks a lot of fair lending boxes. So here you had Five Star Bank operating around Rochester, New York. The bank had a lending map, a lending area, and it had 49 branches across the western New York area. And 19 of those branches were in the broader Rochester metro area, but none of them were within the city itself. So that's a problem. That raises redlining concerns. Why are you making loans outside of the city proper and not inside the city core? And in this instance, the core of the city is where a higher percentage of minorities lived. The second area of fair lending concern with this case was they had that map, but then on top of that, they also deemed mortgages that were outside of their lending zone as undesirable in their policies. In general, that's probably not a great term to use in your policies to classify any loan. It just leaves a bad taste in your mouth. But in this instance, no matter what term they use, what they were really doing by using a term like that is steering their lenders from not making loans in those areas. So the first is redlining. The second is almost bordering on intentional redlining, where you're intentionally saying we don't want to make loans in these areas. The third is a real classic example of disparate impact discrimination. The bank had a policy of excluding mortgages that were $75,000 or less from the majority of their mortgage products. So, for example, a 15-year adjustable rate mortgage, perhaps. They'd say, no, we're not doing loans under $75,000 for those at all. They did that for 7 of 12 of their mortgage products. On its face, that policy is not discriminatory at all, right? That policy applies to people no matter their race, gender, religion, creed, disability. It applies to everybody equally. But it was found here by the New York Attorney General who brought this action that it had a disparate impact on minorities. So the people that lived in the city center and minorities that lived elsewhere in the Rochester area were more likely to be seeking mortgages of $75,000 or less. So then this policy is having a disparate impact on that protected class. So I'll talk about, this is a hot issue right now, disparate impact. At the end, the last case I'll talk about is a Supreme Court case where that's being called into question. But right now, disparate impact is still very much an issue and very much a potential fair lending problem for banks. So what they did, they had a over $1 million fine. They required the bank to change their policies. They required them to open branches in the city center area. So takeaway here is nothing really new, but just fair lending is always a hot topic. So continue to evaluate the geography of where you're making loans. Geography is a really easy, it's a really easy kind of way for regulators to point to that and use it as a proxy almost for discrimination. So we're not saying you're discriminating intentionally against minorities, but by only making loans in these geographic areas where minorities don't reside predominantly, we're going to still find a fair lending issue against you. So looking at the geography of where you're lending, where you're marketing your lending. Also, with the third point on the disparate impact, facially neutral policy of making loans less than $70,000. Anytime you have any lending program or new development at the bank, maybe a new product or new service, a new promotion, have someone put on the fair lending hat and really think through it. Think through, could this have a disparate impact on any protected class? Is this favoring one zip code over another? And just really have someone think through those and take it 2 or 3 levels beyond what you would just think about normally. The next case I'll talk about is Lighthouse. So this one has gotten quite a bit of publicity. It involves marketing service agreements. Marketing service agreements generally the classic example is if you have a financial institution, they enter into an agreement with, say, a realtor where the realtor will provide certain services to the bank and the bank will pay the realtor money. This calls into question the prohibition in RESPA on paying for referrals. You're not allowed to pay anything of value in exchange for a referral of settlement services. So the bank clearly could not pay a realtor $100 for every loan that the realtor refers over. That's just a per se violation of RESPA. Where these marketing agreements come in is HUD, who governed these prior to the CFPB, they'd have enforcement actions and findings where financial institutions would enter into a marketing agreement with a realtor or other service provider where they'd get certain services, but HUD would find that the services did not match up to what the bank was paying. So if you have a bank that is paying a realtor $3,000 a month for marketing services, it could be internet banner ads, access to certain events, the list goes on. They're paying $3,000 a month for that. If they're only getting services valued at $1,000 a month, what the regulators are going to say is, well, that excess has to be for something. And it's not for the marketing because that's only valued at $1,000. So we're going to assume that it's for referrals. So that's a violation. In this case is the first time the CFPB really entered into this marketing service agreement arena. And I think they exceeded really the authority that they have and where they should have gone with this case. So here you had a settlement service provider. A bank wasn't involved here, but they had a marketing service agreement that it didn't detail what the services were. It didn't provide any mechanism to value the service. So without those mechanisms, how are they to know that they were getting what they were paying for? So without those, the CFPB says, well, you didn't value these at all. You have no mechanism to continue to evaluate them. You're paying for referrals. That somewhat makes sense in the world of RESPA. This whole area of marketing service agreements is completely counterintuitive to any business logic. But within the RESPA logic, that somewhat makes sense, and that's where the CFPB should have stopped. But they actually went 2 or 3 steps further, and they said, not only did you violate RESPA by not tying the services to, not tying what you're paying for services to the fair market value and, essentially paying for referrals, but we think that the contract itself, the marketing service agreement itself, is a thing of value if there's any agreement to refer settlement services, even if you did contract for those services on a fair market value. So they went way beyond the facts that were before them and made a completely different conclusion that was not warranted at all with what they were faced with. So what that means is, if you have a bank that has a marketing service agreement with a realtor, and it's a well-crafted agreement, it details in detail what the realtor is going to provide. It provides for valuation of all of those services that they'll provide. It provides for continued monitoring to ensure that the bank's getting fair market value for what it's paying. So you have this agreement that should be ironclad under RESPA. What this is saying is, even in that instance, if the CFPB thinks that there's some agreement that settlement services will be referred to the bank, that they'll use the contract itself as the thing of value that flows from the bank to the realtor and makes it a RESPA issue. Right? A realtor can refer settlement services to a bank, of course. That's not a RESPA issue. You have to have the referral in exchange for a thing of value. So they're saying even if you value and have the contract perfect, if we think that you're getting referrals in exchange for the existence of the contract, that's going to be enough to be a RESPA violation. That's much further than the position we ever saw HUD take. Now, takeaways. I don't think this Lighthouse case necessarily does away with marketing service agreements. I think there's still a way to craft them and still a way to structure them to protect the bank's interest while also getting the marketing that the bank is looking for in these arrangements. But takeaway, they're going to be highly scrutinized. So if you have these agreements with realtors or other referral sources for mortgages, give them a very close look. Have your legal counsel, have internal counsel or internal compliance really scrutinize them closely. In those contracts, make sure that you're only contracting for a specific list of quantifiable services. What I mean by that is something that you can actually assign a meaningful dollar value to. There are some things that are just so general, like access to a realtor's agents or access to the agent list. They're difficult to value. And another thing that's difficult to value is exclusivity. So if you have an exclusive arrangement, that's going to get you an even higher level of scrutiny. So make sure you have a list of things that you can actually value. Make sure that you have a functionality to value them to ensure that you're getting fair market value at the time of the contract. And then on an ongoing basis, the ability to reevaluate that. Make sure you're getting what you're paying for and that it continues to be fair market value. Have controls in place to ensure that there's absolutely no tie between the contract or what you're paying under the contract and the referrals that you may or may not be getting from the realtor or other provider. Here's a scary one. Compliance officer fined $1 million personally, right? That headline should really put the fear deep down in your bones. But this was a pretty isolated instance, and I don't think anything that any of you should worry about. If you're the compliance officer and you're listening to this, I'm not putting this slide up here to convince you that you should resign as compliance officer because you're taking on personal risk, because I really don't think you are if you're doing a reasonably good job. But I put it up here, this can be ammunition for you to use when you're doing trainings at your bank on other areas, that there can be personal liability with compliance issues. So in this case, this isn't a bank, it was a MoneyGram executive who was the head of compliance. He was the chief compliance officer. They found that he knowingly and willfully was just ignoring BSA. So he was not filing SARS. There was not monitoring money laundering activities, ignoring red flags, and he wasn't just doing it negligently. So it's not just that he wasn't smart or he didn't know what he was doing or he wasn't properly trained. It was he knew what he was doing and he was ignoring the law willfully. That's where you get this personal liability. So his inaction led to a lot of fraud, led to a lot of money laundering, and he got banned from banking and fined $1 million for it personally. So I put this again not to instill any panic and fear. I don't think this is any risk, any substantial risk that any of you are taking on, but I do think it's a good case to highlight when you're training or talking to any bank insiders that willful violations are going to subject them to criminal penalties and personal liability. So, and willful violation doesn't just mean that you're embezzling money from the bank. So in this case, I don't believe there was any allegation that this gentleman stole money from MoneyGram or did anything like that. The allegation was really that he just willfully ignored the law. And doing that is enough to subject you to personal liability. Last case I'll talk about is from the highest court we have in the U.S., the Supreme Court, the SCOTUS. So this issue has come up a few times, and the banking industry has tried to get this issue up to the Supreme Court level, and that's the disparate impact standard that we talked about back with the five-star bank case. The standard that says you can have a fair lending violation even if you don't have a policy or practice that is discriminatory on its face. Even if it's completely neutral, it can still be an issue if it has a disparate impact on a protected class. The challenge brought in this case is the statute, back from the 60s on equal housing didn't mention this type of discrimination. So here, the industry is trying to claim that the Fair Housing Act does not authorize disparate impact, that the regulators were not authorized to go that far, that it really only covers intentional discrimination. There were two other cases, Town of Mount Holly and Magner versus Gallagher, that were working their way up to the Supreme Court on the same issue, but then settled right at the courthouse doors. This one appears that it's going to make it all the way and actually be heard by the Supreme Court in June of this year. As you can imagine, this could be a big deal. I mean, the disparate impact theory is a real burden on the financial sector and banks and other financial institutions because it's just an unknown out there. You can control for training and ensuring that you're not intentionally discriminating in any way, and all of you do. But this unknown that's just based on statistics can be difficult. You don't know it until after the fact when the statistics are generated. And it can be really hard to track, and it's almost an unquantifiable risk out there. So it's something to track. It's something that you'll see a lot in the press, I think, as it gets closer. Ultimately, if the case rules in favor of the disparate impact theory, then there's likely going to be no change. If the Supreme Court strikes down that theory, then I think it's just going to be a further fight. So on a temporary basis, if they strike it down, the disparate impact theory of a fair lending violation is going to be gone. But as you can imagine, in Congress, that might not be a popular opinion with some congressmen, and so there'll definitely be a push from some sectors of Congress and from consumer groups to bring back and explicitly pass a law that provides for the disparate impact theory. So I hope this was helpful. Wanted to go through some of these cases. These are good just to highlight what the current issues are. I think they're also good for those of you out there who are compliance officers or who are otherwise responsible for training staff and keeping staff and management apprised of compliance issues, reminding people that these are the issues that people are being fined for. These are the issues that, here are some recent cases from the past 3 months where banks have been zinged for BSA or fair lending or RESPA. Can be valuable and can keep compliance at the front of management and other staff's mind by keeping them apprised of these developments. So if you have questions, my contact information was at the beginning. Feel free to shoot me an email or give me a call. Otherwise, thank you all for listening. Again, I apologize for the way this ended up being broken up, but feel free to use this recording and circulate it within your bank as you feel fit. Thank you.